Good evening. Welcome to Defacto Review, our weekly in-depth analysis on the current affairs. Today we have Ms. Namgil today in our studio. So you can join in on our conversation on MNB World Facebook page and on Twitter with Jargal, #Jargal_Defacto. So let's take a look at today's topics. What is behind proposed amendments to the law on courts? Coronavirus bill submitted by Parliament members. M.Enkhsaikhan's court date postponed. Now let's get into our first topic for today. A draft of amendments to the law on courts is being discussed by Parliament, submitted for judicial legislation to be in accordance with the recently amended Constitution. However, there are two packages of judiciary amendments that have been submitted. One was submitted by President of Mongolia, and the other one was submitted by the Cabinet. So our first question on this topic is that the draft amendments to the law on courts represents a very significant piece of the legislation, so one that would make major changes to Mongolia's judicial system. So is there a need to change this law at the moment? So, and what about the submitted two versions of this?
Okay, so as you mentioned before, and we also know that we have amended the Constitution last year, and a significant part of this amendment involves the judiciary, and especially the appointment and the composition of the General Judicial Council, and also the disciplinary committee of the judiciary become the constitutional organ by this constitutional amendment. So, also after the amendment in this year, January, Parliament also passed a new decree on resolution on the compliance of the ordinary laws to be complied with the constitutional amendment, which actually means that almost 45 laws should be amended by this resolution. So this law on the courts is a part of this process, and legally, actually, the constitution will be effective on this in this May, which means that the General Judicial Council and the disciplinary system should work according to the Constitution, starting from this effectiveness of the constitutional provisions. So actually, legal framework requires these amendments. But at the same time, we have this pandemic happening in globally. So I think it's up to the Parliament to decide whether we should amend it at the time. But without thinking about the pandemic law, the constitutional regime requires these amendments on the judiciary, the law on the judiciary. But there's also, interestingly, that we have two separate amendments now, and the proposal now. The draft provided by the government was prepared by the Ministry of Justice, and as I know, it's been there for the public discussion for some months, and some NGOs, human rights NGOs, and also some organizations actually provided their ideas to the drafts. But about the presidential draft proposal on this law on the court, it was actually a bit of a surprise of the last week. And if we see the content of these two proposals, there are considerable differences regarding how the law initiatives understand how the Judicial General Council should compose, and also the disciplinary commission is also, for example, in terms of how many members in the judicial disciplinary system is also in two drafts. It's totally different numbers are there. So which means that there are totally different ideas on how the main issues of this new court law should be.
Why are both of them being discussed? Are they going to choose one, or are they going to choose the best versions of two of them?
Usually the practice is when there is two drafts regarding the one issue, it's usually up to the Parliament to combine these drafts and to have one draft to be discussed in the Parliament, because otherwise it will be not legally not possible to discuss two different draft on one issue, because it will, contradict each other.
So which one is much more suitable for Mongolia's situation?
That's a hard question, because when I see the two different proposals, each one has one good side and also downsides. But if you would, to be time-wise and to be very general, I would say that the government's proposal on this new draft, new judiciary law, is that some of the provisions are not really complying with the constitutional amendment's main concepts. And also it kind of increases the influence of the Supreme Court vis-a-vis General Judicial Council. But if we see the other draft by the president, the draft also has this spirit of president trying to take back their powers regarding the judiciary, because as we remember, main discussion during the constitutional amendment process was how to limit the presidential power over judiciary. But at the same time, this new draft by the president, his office is also has some provisions, like president will have some power on the nomination of the General Judicial Council, and also disciplinary commission as well, and also when removing the judges, president also has some involvement. So if we say it very generally, this is happening.
So either one, the public just wants a fair and independent judicial system after all, whichever would have chosen. So would these amendments actually, create such a system, and what would you add to either of them to create this kind of system?
First of all, it should follow the main concept and the main regulation by the Constitution, because we did a lot of things to amend this Constitution. It was a big process. So this ordinary laws should comply with the constitutional amendments. And also, if we see it from the good side, like both draft has one step forward, which is that in the last year we have this very internationally not standard provision on the judicial law, that when National Security Commission would have some involvement of the removal of the judges, but both draft now do not have this kind of involvement from the National Security Council. That's also one kind of step,
So is it essential part of judicial system?
I'm sorry, what?
Is that article, could it be essential part of the judicial system?
Yeah, of course. Removing the judges, it's a part of the system that provides the independence to the court. So the international standards say that judges should be appointed without no time limit and without not legally provided procedure. But this legally provided procedure also should follow the Mongolian commitment to the international standards and also constitution. But as I mentioned, this National Security Council involvement was not really in line with all the international commitments.
So you mentioned that the international standard. Mm-hmm. So are these proposed amendments reach this international standards fully?
I have to see it very carefully in order to, fully conclude on that. But still, there are different studies on that, and there are, of course, from the NGO side and civil society provide a lot of recommendations in regarding to this. So some of them actually follow that, but still, this, especially the composition of the General Judicial Council, we still have this power. Tension, I would say.
Right.
Yeah.
So are the proposals made by the NGOs and other companies being included in these amendments? How can some NGO, make a proposal and actually affect the process?
Yeah, we have a law on legislation which requires the public consultation and the drafting process. And now the draft's already in the parliament, which means that law initiators, which means that Ministry of Justice and the President's office did some public discussion on this draft, but still we have people have a voice and also have legal possibilities to affect during the parliamentary discussion as well. Yeah.
Okay, so thank you for that. Now, let's get into our second topic for today. On April 17th, Parliament members Enksaikhan and Nyambatara submitted a bill on curbing the spread of COVID-19 to the Speaker of Parliament, Zandajata. So our first question about this topic is that in this bill, is there any articles that might limit free speech?
Mm-hmm. So this special law on the COVID pandemic, this is very special to Mongolia, and probably the first time we discussing this kind of law in Mongolian and the democratic history. And if you see it from the general, when you see the draft generally, it's this law tried to legitimize a lot of the measures that the Mongolian government is taking now, because it seems that since we didn't have this kind of process before, which means that the laws did not really comply, in line with all the measures that might needed during this kind of pandemic. So I think it's good that we have some kind of law that legitimizes all the measures, because otherwise there should be a lot of discussion on whether, for example, this suspension of the travel, for example, from the city into the outside of city, it didn't really, for example, if you see the special commission's decree, it didn't really cite any laws, which means there might not be law providing the power to the commission, So this law provides all the measures that can be taken, and that's a good thing. But still, we have to see it from the human rights perspective, because especially during this kind of pandemic or this kind of emergency situation, it's usually the human rights. It's usually easy to violate the human rights, and people's alertness toward the breach of human rights kind of decreased usually, because there are a lot of fear and a lot of other things to consider. So this law provides that the, for example, CRC, the Commission on
Communications Regulation
Commission. They can, for example, they can suspend the websites and the social media when there is some kind of misleading information is spreading.
Right.
But at the same time, this provision also say that they can also suspend these websites and the social media if they think that there needs to be there is this kind of situation which has, for example, which means that there shouldn't be any misleading information, but it is also, if we see it from the legal side, it's kind of really broad, like when the CRC thinks that, not exactly CRC, it's also requested it should be requested by the police, I guess, and the CRC can suspend, for example, when there is a situation where prevention measures should be needed, for example, which is very vague, or there should be some situation like prevention of the COVID. We need to prevent, so that we have to suspend this website, whatever,
Right.
It can read this way. Probably it's just technical, bad writing, but still it's very vague. And also, together with this COVID law, there are separate amendment proposals is also happening in the parliament, which is the law on the disaster protection. And I think this, because this COVID law has a time frame, it will be not effective when there is corona, this pandemic finishes, or in the end of this year, it also has to finish the effectiveness of this law. But this law, this draft law on the disaster protection, this is a permanent law, and this law also has a special provisions that say that they can, the competent agency can restrict broadcasting, like, and not just the website, but the other medias as well,
Right.
and also websites and social media as well. And another thing is that this COVID law has some good side, which is that it has special provisions on whenever government takes special measures, which is restricting the human rights, there should be some standards And the law provides the standards, which is in line with international human rights standards. First of all, for example, whenever the measures the government wants to take, it has to comply with the law first, and it also has to have a legitimate aim, and then it also has to have to be necessary and proportional, which means that we shouldn't restrict overall country when the pandemic is just in the one spot or whatever. I'm just guessing, but still there should be this necessary and proportional tests should involve. For example, when there's this just not to forget, there's another provision which requires a lot of attention, is that this law also said during this heightened framework of disaster prevention, there shouldn't be any convening of the people more than 4 people. I mean, and also there should not be any assemblies and the gatherings, which takes us to ask the question about how about election.
Right.
Yeah. So, but still, they have this human rights standards, but this different law on the disaster protection does not require any human rights limitation or human rights limitation standards, which means that whenever the government agencies think it's required, they can do it without considering is it proportional, is it necessary, is it legitimately, is there a legitimate aid or whatever,
So if this law is passed, would it really affect the election? Because South Korea just held their election in hospitals and people wearing protective equipment.
Election is not just giving votes during the voting day. Election starts, actually election already started,
Right.
There are a lot of process actually
Campaigns
happening
have
now.
already started.
And just before, especially during the campaigning time, the parties and the candidates also have a right to meet with people and organize this kind of public events, which will not be in line with this COVID law, I guess. So probably if the parliament passes this COVID law, probably they should think about this election law as well. Or if the parliament thinks that the election will be happening anyway, how the campaign will work. So
Right.
This is the thing that we should talk about, I think.
I see. So have there been any attempts to undermine democracy in Mongolia using this pandemic as an excuse?
For now, I cannot say that, because the drafts are already just a draft,
Right.
but still we have to really look into the wordings of the draft, that whether it can be abused or not. So that's up to the human rights NGOs and lawyers and all the people who are considering about that, because we all know that international media is providing this kind of trend that they're using, especially this pandemic timing. The authoritarian government is kind of abusing this process. So. Yeah.
So what about the example of other nations? Were they prepared with this kind of legal environment, or are they just making another bill just like Mongolia?
I'm not sure. I haven't seen that.
Okay,
Yeah.
see. Thank you for that. Now let's get into our third topic. Former Prime Minister M.Enkhsaikhan's next court hearing has been postponed, and he will be detained until his next appearance in court. This caused a huge uproar in social media this week. So there has been a lot of conspiracy theory about the police are detaining him because he was way too active on social media. So is detaining him actually illegal, as people are saying?
So yeah, that was a big issue in last week, and I think we should distinguish 2 different stuff here. And one is this: what is the grounds for taking this special measure of detention, and the restraining measure of detaining. And the other thing is that the secrecy of the investigation, because what I understand from the media, because we haven't seen the court paper of what actually laws this judge cited in his or her decision. Yeah.
Right.
But we just have information from these new medias. but I've read the interview of the advocates of the Mr. M.Enkhsaikhan, and as I understood from that, the persecutor say that he's too active on social media, which might reveal some kind of secrecy, and also which is trying to influence the judicial process or something, right? But if we see the criminal procedural law, all these things are not the ground for this taking these measures. If the law provides the first of all, it's whether this accused or defendant's trying to escape from the procedure, and as I understood, he didn't really do that. I'm not sure. I'm just you're talking about the media stuff, and also the second thing is that whether the defendant or accused harassed or threatened the other participant of the process, like judge or prosecutors, victims, whoever participant in all the investigative process. And the fourth is whether he is whether defendants try to do another crime. And the fourth measure is that whether he is not compliant with the investigators or prosecutors' notice to appear. But as I understood, he was complying all the procedure, right? Of the prosecutors, and all the calls he was appearing, all the call he was in contact with all this procedure. So just from this information, I can surely say that it's not sounds legally from what I said.
So shouldn't the detaining order issued by the prosecutor or the judge be open to public for any reason?
Yeah, it can be open, but it probably takes some time to draft and publish it, as I understand. And I think the advocate or the people working for the defendant side, they would publish it any soon, I guess.
I see. As for our second question, he was allegedly being detained for being too active on social media, as you said. So, what are the grounds? Actually, what are the actual claims for this? Because the prosecutors are saying that he could affect the trial by being too active on the social media. So is this really true?
As I mentioned, only the reason which might relate to this detention measure is that this harassment and the threatening part. But the word affect, harass and threat is different word, different meaning, I guess. And also the legal science, I mean the international standards on human rights. What is the main aim of actually detaining? It's the harshest measure of the court before establishing the defendant's actual guilt. He's still not guilty, presumed not guilty until proven by our constitution, which means that the detaining is the harshest measure. But in order to use this measure, it's usually the main of the detention measure throughout the world, throughout the international, the human right, the country where human rights is respected. It's usually he is escaping the investigation. He does not comply with all the procedural stuff. But like, for example, threatening or harassing or doing another crime, these are totally different, I would say totally different grounds that should not be considered here, because I think it's out of Mongolian law, but still we have to really critically read and really critically change this law.
So was there any, actual evidence that he was trying to release secret information on his social media account?
I don't know, because media does not provide this kind of information, and according to his advocates, they said there was no reasonable facts or reasonable information regarding his escape or whatever. And also, even though if we think that he was active on social media and publishing the procedural documents, investigative documents, and talking about his side of the story, it's also part of his defense right, and also he is also part of his speech right. So I don't think it involves secrecy or something like that, because disclosing the secrecy of investigation is a totally new crime, different crime. It's not the ground for the detention, but it's a different crime.
I see.
Yeah.
So lots of people are saying because of this, many people who openly criticize the current government could be detained next. So what if they actually detained him for being too active on the social media? Would other people be afraid because of this?
I cannot say that, but still this defendants side, the defense team, they still legally have a right to petition and change this detention. So I hope they will use that possibilities, I guess.
Right.
Yeah.
So what do we need to establish just and fair judicial system? As there are 2 amendments being discussed. So how do we create this kind of?
That's a very big question, because basic principle of judiciary is that we provide judiciary the independence in order to secure the right to fair trial and right to be equal before the law. So, which means that if we see the judiciary as a whole, there are institutional arrangements which are regulated by this kind of law on the judiciary, law on the judicial disciplinary process, or law on or even the constitution. And also there are procedural aspects of all the judicial process, which means that the law we discussed, that law on the criminal procedure, law on civil procedure, law on administrative procedure, which is all provides these special procedures. That because all the special procedures have human rights aspects everywhere. So, and also I think it's also up to the judge's personal commitment to the human rights and to the justice also involves this kind of procedure. So this is a really complex procedure, and as I hope that this new law on the judiciary is stepping forward in terms of institutional design. The next one we should actually still think about is procedural, like for example, as I said, that we have to think about the grounds for detention again, because law, for example, provides for, but there are special researchers said that the 2 of them actually probably not really related. So we also have to reform this criminal procedure law as well.
Right.
Yeah.
So is there any international organizations that look through all these and enforce human rights in any countries?
We are a part of UN system, of course, but the UN system have this petition procedures, but it doesn't really affect Mongolian constitutional jurisdiction, because we as a country is separate. We have own sovereignty and own independence, which means that the Mongolian judicial system has a final jurisdiction on Mongolian territory.
Right.
So, but still we have a lot of procedures to remedy if there is a human rights breach by the government or by the police as well.
So
we have to use all
human rights breach, who
yeah.
can we, who can we reach to be to have it solved? If the government has a breach of human rights,
there are constitutional courts we have, and also Human Rights Commission. Of course, there are a lot of different procedures involved in that, and some of them do not takes all the issues. They have different jurisdiction on different procedures of life. So we have to navigate all the system together with lawyer, actually, because it's not easy to understand how this process. But also the general public and the public media is one form of oversight over government's action. So in that case, I think that using social media, and for example, this Mr. M.Enkhsaikhan's case is kind of providing us the information regarding what's happening in the judiciary. Right. It's also up to our right to know, and up to free speech, his free speech and his defense rights. We should know that it's not a breach of secrecy of investigation. Right. I would say. Yeah.
Okay, so thank you for that. So unfortunately, that is all the time we had for today. We will see you next week with more topics. Have a nice evening. Goodbye.
the fund of future.